going to be talking this morning about recent developments in property licensing. Tara's opening she'll be looking at Rakusen, Maharaj and Global Guardians. And then I'm going to tell you about Knapp, Rahman and Hussein with a little add-on for the new HMO regulations. As those of you who are familiar with this format will know, this is being recorded. It will be available on our website later for reference. And there is at, I think, the bottom of your page, a Q&A tab in which you can put any questions you might have during the course of the webinar. We'll respond either in the panel as we go along, or at the end of the webinar. It bears saying that we might not be able to respond to all of the questions. If there are any questions that we haven't responded to, that the asker or indeed someone else would like an answer from us on, do feel free to get in touch with us. We've got our email addresses at the end of the slides for those of you who I imagine will be very few who don't already know our email addresses. And with that said, let me please open the slides and hand over to Tara.
Thanks, Ricardo. I think we need to move forward through a few slides. So we had a little outline there of what I and Ricardo are going to talk about this morning. Just to say and add to Ricardo's welcome remark, thank you very much. So pleased to see so many people attending this morning and so many familiar names and faces on the list, as well as lots of people from all over the country. It's great that one of the advantages of these webinars is we can reach those of you outside of London. And I'm sure there'll be very different experiences from around the country to share with different tribunal panels. So first of all, we've got Rakusen and Jepsen. I'm going to start with the big one because it's not every day or even every year that we have the Supreme Court discussing licensing matters. So unless you've been living under a rock, I'm going to pause just to say, Ricardo, that I think we're having some issues with the slides and we keep flicking back and forth between the PowerPoint and the slides itself, but I just need you to go forward to the next one when you're ready. Sorry. Thank you. That's great. Yes, so unless you've been living under a rock, you've probably heard about this decision, which was handed down in March, which concerns rent repayment orders, or RROs, which are something that is very difficult to pronounce in an Irish accent. The rent repayment orders can be made at the FTT's discretion against landlords who've committed housing-related offences, particularly failures to licence, and often comes up in the context of HMOs. Now, Section 40, subsection 2 of the Housing and Planning Act 2016 describes RROs as an order requiring the landlord under a tenancy of housing in England to repay an amount of rent which has been paid by the tenant. And is that tiny little piece of language, that sentence, which formed the heart of this case. Cutting to the chase, the Supreme Court confirmed that language means that rent repayment orders can only be made against a tenant's immediate landlord, and that needs to be the landlord under the tenancy which generated the rent which is now to be repaid, or alternatively, of course, the rent which might have been paid by universal credit and which would now need to be repaid by the landlord to the relevant local authority. It had been argued that rent repayment orders, that Section 40 subsection 2 should be interpreted so that rent repayment orders could also be made against superior landlords, so that's either a freeholder or anyone who acted as an intermediate landlord within a chain of lettings. And many of you, of course, will be familiar with what so-called rent-to-rent setups, where landlords might set up a company. It is the company which is granted a tenancy agreement, and you will have a whole series of lettings from companies who can effectively disappear very quickly at the first sign of trouble, particularly if a local authority tries to take enforcement action against them for housing offences. On the next slide, we'll see the court's reasoning for this, which is effectively, the court said that the most obvious and straightforward interpretation of that language from Section 40 subsection 2 is the best. that it is the rent paid by the tenant refers to the rent paid under the tenancy agreement between the tenant and their immediate landlord. Now, any other interpretation, it was said, would require putting a gloss upon that language, and having examined the statutory background, it was felt that that was not a gloss which Parliament had intended. In particular, the court said that the Housing Act 2004, as it was originally enacted, had made it very clear that rent repayment orders could only be made against an immediate landlord. And it was felt that when amendments to those provisions were introduced by the Housing and Planning Act 2016, that Parliament had not necessarily intended to widen the range of people against which the orders could be made. Now, it will not surprise anyone involved in this sector to know that the respondents who were resisting this appeal, or sorry, bringing this appeal, I believe, and Safer Renting, who made it an intervention before the court, both lean very heavily on evidence of malpractice within the sector and looking at very poor housing standards amongst particularly rent-to-rent landlords. Now, the court did acknowledge that issue, and it acknowledged and accepted that its interpretation of Section 40 made rent repayment orders less effective as a deterrent to rogue landlords. But what it said was effectively that it was for Parliament to decide whether or not the regime should be expanded in order to direct remedies towards superior landlords or intermediate landlords. There's been extensive lobbying around that issue to introduce amendments to that effect. All I can say is that the first draft, which has been published, of the Renters Reform Bill did not include anything on rent repayment orders. So we'll need to see as it moves through the legislative process in the Commons whether or not anyone might succeed in introducing amendments to that effect. In the meantime, the court emphasised that there are a large range of other sanctions available against dodgy landlords or anyone who had been committing these offences, and that includes prosecutions, civil penalty notices, in the event that you can prove offences have been committed, banning orders, etc. There's also provision under the Insolvency Act 1986, which provides that effectively if company directors are thought to be putting companies into liquidation for the wrong reasons, there are sanctions that can be taken there. And that's something that I think not all teams are aware of, but it is an interesting remedy which might be worth looking into. What I would also add on the next slide, thank you, Ricardo, is that the court did include confirmation that criminal liability, as opposed to liability to receive a rent repayment order, is not limited to intermediate landlords. And you can see the language there. That statement is of wider application, obviously, to anyone who's involved in taking enforcement action in a context like this. It's certainly my experience that sometimes when civil penalty notices are issued to multiple people at a single property, such as freeholders and managing agents, they try to argue that there shouldn't be enforcement action brought against more than one person. Now, I've never really met a tribunal that was willing to entertain that argument seriously, but I would say this is quite a helpful confirmation that that sort of argument is ill-founded and unlikely to succeed. So that's it on rent repayment orders. Probably of greatest interest, obviously, to people who are acting for tenants and helping them bring rent repayment order applications. But of course, a reminder that local authorities are also entitled to do that and might be willing to do so to assist the tenants alongside serving a civil penalty notice. The second topic I wanted to cover this morning is to do with the adequacy of reasons which are given in notices served under section 249A. So this is when, on the next slide, thanks. This is when you are issuing a civil penalty notice to someone who has committed an offence. Now, the reason I wanted to bring this up is because, again, in my experience at least, this seems to be an issue which comes up repeatedly, if not in fact regularly, before the first tier tribunal, and is very frequently something that's argued on behalf of the recipients of notices who are bringing appeals, but also frankly is an issue which seems to very often exercise and excite the tribunal panels themselves, and they seem to take this issue very seriously. So you'll know that obviously when you serve your penalty, you first have to follow the procedure laid down by section 13A, and in particular your notice of intent and your final notice will need to set out the reasons for proposing to impose the financial penalty. And I've given you the language in this slide because that's That's all it says. It doesn't actually, the statute doesn't prescribe at all any particular standard or particular details that need to be included within the reasons. And I would also note, because it is of some relevance, that paragraph 10, which deals with the tribunal's powers on an appeal against a civil penalty notice, confirms that the tribunal's powers are to confirm or cancel the notice, but it can also vary the notice. And the matters in the notice that it can vary are not prescribed. So in my view, I would certainly argue that the reasons themselves could be varied, improved, or clarified, potentially if need be. Now, there's two main cases on this. The main case, or the first case, is Eunice. And for some reason, this doesn't seem to be particularly well known, certainly not amongst panel members and sometimes not amongst practitioners either. It is a reported decision and it's available on Westlaw and I assume on the Upper Tribunal's website. The deputy president considered what should happen when it's alleged that reasons given in a notice are inadequate. So first of all, the standard of reasons, and then second of all, if the reasons are in fact inadequate, what are the consequences of that? Now, on the first issue, the standard of reasons which will be deemed adequate, the deputy president simply said the reasons must be sufficient so that the person who receives a notice can understand what conduct is said to amount to their offence, and so they can then participate in responding with representations and then potentially challenging the notice by way of an appeal before the tribunal. And he said there's no other sort of technical standard that has to be met. And I think reading between the lines of his decision, he's suggesting that the tribunal should approach scrutiny of reasons in a notice with a certain amount of benevolence, and perhaps shouldn't be unduly quick to find that those reasons are inadequate, because frankly, the local authority is given quite a wide amount of discretion as to what level of detail is necessary. But secondly, and I think more importantly, he went on to hold that even if the reasons in a notice are inadequate, that does not automatically render either the original notice of intent or the subsequent final notice null and void. Instead, the question for the tribunal considering arguments about this is to look at whether or not the recipient of the notice has actually been materially prejudiced by the defects in the notice, and to look at whether or not they've been able to fairly put their case on representations and then in an appeal. And he relied for that approach on J. Anthan, which is an immigration case, but is the leading authority from the Court of Appeal on the issue of where a statute does not prescribe consequences for a breach of its provisions. So where you have a statute that says you must do X, but it doesn't set out what should happen if there's a failure to do that action. And so the Court of Appeal endorsed the approach, which is to look at the statutory objective and framework, to ask whether Parliament would have intended the breach to be fatal, and if not, then to go on to a second stage, which is considering whether or not there has been substantial compliance with the requirement, whether or not there's been prejudice, and where the overall balance of justice lies. And the Deputy President concluded in Eunice that in the specific instance of civil penalty notices under the Housing Act, Parliament would not have wanted notices of intent or final notices to be automatically treated as null and void. It would have wanted there to be a more nuanced examination of all the circumstances to look at whether there's been fairness to the recipient. So that was Eunice. And then just last year in Maharaj, we had a decision from His Honour Judge Hodge KC, who took a very different approach. And he thought the whole matter should be approached with much more degree of severity and strictness. He outlined that he thought reasons in notices had to be identifying clearly and accurately the details and the particular respects with which it said there's been non-compliance by a landlord, in that case with licence conditions which were said to have been breached. And secondly, that local housing authorities must bear firmly in mind that this is an alternative to criminal prosecution. He comes very close to saying that the reasons in a notice should be akin to the counts on an indictment sheet. Now, the facts of Maharaj were different. What had happened was the notice of intent alleged that there had been a failure to comply with a licence condition, which was all to do with failure to produce a gas certificate by a particular date. And as the evidence emerged in cross-examination at the appeal hearing, the tribunal eventually concluded that the offence which had initially been pleaded in the notice had not been committed, but a different offence had been, which was a failure to produce a different gas cert on a different date. Now, what the first year tribunal had failed to appreciate was that that second offence was actually time barred because the notice of intent had been served more than 6 months after it was committed. So there was a compelling reason, I would say, for Judge Hodge to obviously allow the appeal on that ground. But it's not clear whether Judge Hodge was aware of the decision in Eunice, whether or not that had been cited to him or Jay Anthan. And it's also not entirely clear, given his comments about waving imaginary magic wands, whether he was aware that he had a power to vary the final notice. Stands in somewhat in contrast with Eunice. Now, on the next slide, just to briefly explain, I'm instructed in a case by Welland Hatfield, who I believe are with us this morning. So good morning, Mateus Plaza, my litigation officer, where basically the first year tribunal quashed notices because it held that a notice of intent was invalid. It's probably fair to say this was a case involving breach of management regulations, and the notice of intent did not give many details of what was actually alleged. It simply said, for example, breach of Regulation 4, and it didn't specify exactly which provisions within that had been breached. But the final notice did, and it gave all the details which could possibly have been expected. Now, the FTT said that didn't matter, and because the original notice of intent was invalid, the whole matter felt to be quashed. When invited to grant permission to appeal on the basis that Eunice applied, it said that it thought Eunice was a bad authority and it preferred to follow the approach from Maharaj. So we've now been granted permission to appeal that decision effectively on the basis that there seems to be a clash between those two authorities. So hopefully in the autumn, we will have some clarity on that. I'd also point out that this is probably of some relevance beyond just civil penalty notices. The decision of Cancel from a couple of years back involved a notice to vary a HMO license. And again, Judge Elizabeth Cook there held that defects in the notice did not necessarily render it null and void. And she also followed the approach in Jay Anthan. So hopefully this will be something that we can resolve and there'll be a bit more clarity on going forward. Now, the final point I'm going to discuss, and I'm going to have to try and cover this very extensive decision in only about 5 minutes, which doesn't give me much time. This is a case which concerns property guardians and obviously people who live in or occupy a vacant building to secure it against squatters and vandalism. If you are fascinated by the thrilling world of property guardianship, the good news for you is that the excellent Dean Underwood and I did a whole webinar last year just on that topic. So it is on our website and I would refer you to it if you can't think of anything more interesting to do in your spare time. But in the meantime, this is a fairly mammoth decision covering some fairly meaty issues which are going to go up to the Court of Appeal in October this year. And you can see we've got about 4 meaningful grounds of appeal here. The first is whether or not premises occupied by guardians are in fact licensable as HMOs. And then the second issue is whether or not the guardianship companies which operate and manage those premises are persons in control or managing and therefore are amenable to enforcement action. In this case, they had received civil penalty notices for failing to license the premises as a HMO. And there's 3 main arguments under that heading, which I will try and briefly cover as quickly as I can. On the next slide, because there's quite a lot of parties involved in this case, I've just briefly set out who they are because it's slightly difficult to consider the complexity of this issue without a brief explanation. There's a freeholder of the premises called NHS Property Services Limited. It was an NHS body. They entered into an agreement with a company called Global Guardians Management, GGM. And the upper tribunal held that the agreement between the freeholder and GGM was in fact a tenancy agreement. It sort of described itself as a sort of agreement for services or an agency agreement, but it was construed that actually the meaning of it was as a tenancy. And that had some important consequences when it came to looking at whether GGM was a person managing or in control. GGM then entered into an intercompany agreement with a sister company with whom it shared common ownership and a sole director, and that was Global 100. And it was Global 100 which then went out and actually found the guardians who took on as occupants of the properties and granted them license agreements. Eventually, they tried to get vacant possession of the premises. And when it came to bringing possession claims against the guardians argued they were tenants rather than licensees. That argument was rejected in a case called La Leva, which you can see the citation below. You might have come across that decision, and it's actually the same building as this, and suggests that very often the guardian occupants of these premises are licensees rather than tenants. So the first issue on the next slide is the question of whether or not these premises are in fact licensable as HMOs. The sole argument that's being put forward here is based on the standard test and section 2542D, which requires that to be a HMO, a building needs to be occupied as living accommodation, which constitutes the only use of that accommodation. Now, Global Guardians are arguing very ingeniously that that basically there are two uses of this building, because people live there as residential accommodation, but they're also providing a security function. Now, this argument has already been considered in another upper tribunal decision called Global 100 and Jimenez. And Jimenez has been conjoined with Hounslow, and they'll be heard together on this ground of appeal and in the Court of Appeal. And you can see that what Jimenez held was that use does not mean purpose. It doesn't matter if the purpose of people living there is to secure the building, that the only use they actually make of the premises are purely residential in nature. Moreover, that the purpose and interpretation of Part 2 of the Housing Act 2004 is important, because that purpose shouldn't be watered down by allowing premises to escape regulation. The reach of the regulatory regime should not depend on the parties' contractual intentions. So it's not for the parties to sort of opt out of the regulatory regime by saying that they don't intend the building to be a HMO effectively. And finally, the actual license agreements used by the Global Guardians company actually prohibited the occupants from doing any other use of the premises. They weren't allowed to run another business or to carry out security functions. So we'll see what happens with that on appeal. The second issue is then this issue of whether or not GGM and also Global 100 were persons managing or in control. Now, the first argument here is Global Guardians Management saying that they didn't have a tenancy agreement of this building. It's a rather fact-specific argument, and I don't necessarily think there's much time to get into it this morning, but because they are a lessee, that brings them within the scope of section 2633, and means they are capable of being a manager of the premises and therefore receiving a civil penalty notice. And obviously, if they're not a lessee, then they can't meet that definition anymore, and it all falls away. I think this will be of interest to anyone who is advising the companies that run these operations, but also freeholders who might contract with these companies. And of course, we know that includes a lot of local authorities around the country, and so potentially their legal teams who are here this morning. I don't think either this particular freeholder or GGM realised that, in fact, the freeholder might have been granting them a tenancy agreement. And there's probably important implications that flow from that, as not only in the licensing context. So worth finding out whether that's something that might affect other properties and other companies. On the next slide, we then have, I think, what's going to be a really crucial ground of appeal in this case, and of much broader relevance beyond the property guardianship world. And that is the question of whether or not rack rent can be comprised of license fees. Now, this is important because it links into the definition of who can be in control of premises. And here we know that the occupants of the premises were licensees. And so it's being said that whatever they pay the companies can't be a rack rent, because rack rent is defined by section 263 subsection 2 as, I quote, a rent which is not less than 2/3 of the full net annual value of the premises. And so this is a pure point of statutory interpretation. You know, can rent in this context be interpreted broadly enough to include license fees? Clearly, Hounslow, who are instructing me and our colleague Ranjit Bose KC on this appeal, will be arguing that the purpose of the Act and making sure that unsafe premises are licensed means it's crucial that this would be the case. But we can all think house share arrangements and so on, where people share rooms, they might have the status of licensees. So again, would apply potentially to lots of different kinds of premises. And then finally, I think we have this issue of evidence of the level of the rack rent. And this is my final slide, I believe. So the issue here is because rack rent is defined as not less than 2/3 of the full annual net value of the premises, the question arises as to what evidence the tribunal needs to have before it in order to judge what the annual value of the premises would be. Now, in many cases where you have a single house, as it were, a former family home, it's quite easy to get an estate agent around who can tell you what rent that place is going to achieve annually. In the guardianship context, it's very difficult to try and judge what the value of a vacant building that's awaiting redevelopment, an empty office premises, etc., what that might be. Now, the way that the tribunals approach this in this particular case at the upper tribunal was to say, well, we know how much money they achieved at the premises every month. The occupants collectively were paying about 15 grand. And the tribunal said, well, as a specialist tribunal, we think that's pretty good evidence of the guardianship companies achieving the best possible license fees they could get on the market. That's being challenged on the basis that it's not sufficient to meet the criminal standard of proof. And there's a range of interesting questions arise from that as to whether or not expert valuation evidence might be required in order to determine what the applicable value of a premises would be for this purposes. Is also looking at the limits of what the FTT or the upper tribunal can decide as a specialist tribunal, and whether or not you can draw inferences from the evidence before it. So again, I think that's likely to be something that will impinge on lots of different HMO licensing cases, particularly if there's any dispute about who is in control of the premises. So I've run a little bit over time, with apologies to Ricardo, but thank you very much.
Thank you, Tara. There are 4 developments I'd like to mention. The first 3 are recent or upcoming decisions of the Court of Appeal and the Upper Tribunal Lands Chamber. And the 4th, as I said in outline in opening, will be the Asylum-Seeker HMO regs. So starting with banning orders, I want to look at Knapp and Bristol, which was the first appeal to the Upper Tribunal arising out of the banning order provisions in Part 2 of the Housing and Planning Act 2016. The facts are, in brief, that the appellant had been a relatively large portfolio landlord for 30 years. Many of her properties were required to be licensed and therefore fell also within the management regulations. A number of 249A penalties were imposed, some of which Miss Knapp appealed against, most of which unsuccessfully. And then, most importantly for this decision of the Upper Tribunal, she pleaded guilty to 8 criminal offences, mainly of the management regulations, all of which were banning order offences under the regulations that you can see listed at the top of the slide there. She was fined £22,000 for those 8 offences, between them, I stress. Because those offences were banning order offences, the council went on to consider whether to seek a banning order. The procedure for doing that was that it sent her a notice of its intent to seek a banning order, and then, having received and considered her representations, it brought an application to the first-tier tribunal. The first-tier tribunal granted a banning order, preventing Miss Knapp from letting property, which is what she'd been doing, from engaging in letting work, which she hadn't been doing, and from engaging in property management work for 5 years. She appealed from that decision on 7 grounds. The Deputy President dealt with it slightly differently, and one of the grounds wasn't advanced, but I'm going to talk about some of the grounds. The relevant provisions are in, as I said, Part 2, but specifically sections 13 to 16 of the 2016 Act. And the most important provision, to my mind, is section 16, most of which I've set out here. What do we take from it? Well, firstly, that the FTT has a discretion. It may make a banning order. Secondly, that the discretion only arises where a person has been convicted of a relevant offence and that person was a residential landlord or agent at the relevant time. That's to say that a person might no longer be a residential landlord or property agent, but might still be subject to a banning order. That's an anti-avoidance measure. Thirdly, that section 15, which we'll look at in a moment, has to have been complied with. And fourthly, the statute sets out relevant criteria that the tribunal must consider when deciding whether or not to make a banning order. And the most important of those for the purposes of Knapp and Bristol is the first of them, the seriousness of the offence for which the relevant person has been convicted. I said a moment ago we needed to look at section 15. What does section 15 provide? Broadly, service of a notice containing prescribed information within a particular time and allowing representations to be made in respect of that notice, also within a particular time. And the important point about section 15 is that section 16, which we looked at a moment ago, provides at subsection 2 that the local authority must have complied with it in order to obtain a banning order. What are the effects of a banning order? Well, I don't have a slide on that, but I can tell you them. The effects are that a person may not do what's excluded by the order. So in this case, it was all of the things that a person might be excluded from doing: letting property, being a letting agent, or conducting property management work. And that is on pain of criminal conviction under section 21. A person who is banned may not hold a license. That's various sections of the Housing Act 2004. And the consequence is that the council is likely to be required to impose an interim and subsequently final management order under sections 102 and following of the 2004 Act. There were a number of issues in this appeal, as I've said. Some of them were specific to Knapp. Others were of wider application. I'm going to focus on the more interesting, wider ones. The first issue was that it was asserted by Miss Knapp that the FTT had delegated to the magistrates the function of determining the seriousness of the offence under section 16. And the way that it was put by her counsel was that the FTT was required to disregard the fine that the magistrates had imposed upon finding that there'd been a breach of criminal provisions and consider the question of seriousness afresh for itself. That wasn't made out, and the relevant passages for anyone interested in that are 52 and 57. In short, the FTT was entitled to consider what the magistrates had determined. The simple reason for that is that we don't get to the first tier tribunal without first having gone through the magistrates court. You need a relevant banning order offence to seek a banning order. The second interesting and issue of wider application was an assertion that the FTT ought to have considered for itself whether the offences had been committed. That is to say that Ms. Knapp argued that it wasn't entitled to rely on guilty pleas and convictions founded upon those guilty pleas. That too was not made out. That's at paragraph 68. Sorry, I just noticed it on my slide. They're in a different order to how I've got them in my notes. The third was that the FTT was not entitled to rely on its expertise and experience as to the levels of penalties that tended to be imposed by the magistrates court. And that was given extremely short shrift at paragraph 43. The fourth was that a banning order could only take effect in relation to the grant of new tenancies. Now, I put this fourth, but it's probably the most important point to come out of the decision of the upper tribunal, the decision of the deputy president. What Ms. Knapp argued was that a banning order was only capable, as a matter of jurisdiction, of preventing a landlord, that's because those are the facts of this particular case, from granting a new tenancy, and wasn't capable of preventing a landlord from continuing to manage an existing tenancy, that is, a tenancy that was entered into prior to the banning order being imposed. And if I may say, that was rather a hopeful submission made on behalf of the appellant. which was given a total of 4 paragraphs of consideration by the upper tribunal from paragraph 62 to 65. And needless to say, it was not made out. What does that mean? That a banning order relating to letting property prevents a landlord from letting, that is to say, continuing to let property that was already let. And the fifth and final interesting point to arise out of NAP was that the FTT, it was said, was not entitled to consider a person's track record when deciding whether to make a banning order, and the Deputy President was not at all interested in that argument. It was perfectly entitled to consider a person's track record. Indeed, the worse a track record, the more the council had attempted to ameliorate behaviour by non-nuclear options, the more likely it would be appropriate to grant a banning order, and that was in paragraph 69. It follows that the appeal was dismissed, and Ms. Knapp didn't make, as far as I know, or at least I haven't seen, a further application for permission to appeal to the Court of Appeal, and from memory, she's now out of time. The next thing I want to look at is recent decision of the upper tribunal again on 249A penalties. As perhaps everyone in the room will be aware, in the case called Marshall, Judge Cook decided this, paragraph 54, the ratio effectively being that on an appeal to the first tier tribunal from a 249A penalty, the FTT had to take the council's policy, if it had one, as the starting point. I interrupt myself there to say, if you don't have a policy and you are a local authority, write a policy, so that on the facts of Marshall, where the local authority had imposed a penalty of £5,000 in accordance with its policy, the FTT was not entitled to decide to depart from it for no relevant reason and instead impose a £1,000 penalty, just because that's what the FTT would have imposed had it been the primary decision maker. Instead, as this passage at paragraph 54 and paragraph 55 is also helpful, what the FTT was required to do was start from the policy, consider whether to depart from it, only depart from it if the appellant overcame the burden of explaining why it should be departed from against the particular context of, as you can see at the bottom of paragraph 54 here, ensuring the objectives of the policy are met. And from memory, at paragraph 85, of ensuring fairness and transparency as between offenders. Rahman was a case in which the upper tribunal was asked to consider what seems to me to have been the logically consequent question, which was this: if during the course of the appeal, the appellant raised matters of which the authority had been unaware, which, had the authority known at the relevant time, would have resulted in a higher penalty being imposed in the first place, was the FTT entitled or required to apply the council's policy? What the FTT had done, well, I suppose I should tell you the facts. The council had imposed a £5,000 penalty, thinking that Mr. Rahman owned fewer than 5 properties, and that meant under its policy that a £5,000 penalty was appropriate. It emerged during the course of cross-examination that he in fact owned more than 5 properties. And the question was, should the FTT therefore have increased the penalty under the council's policy, which it refused to do? Waltham Forest said, of course it must. The upper tribunal said this at paragraph 14. In short, yes, it should, subject to Marshall. And this was a strange case, as anyone who's read the decision will have seen, because on the day of the appeal, it emerged that the person who purported to be the appellant at the appeal was not the appellant at all. So much of the appeal fell by the wayside. The last case I want to look at is about the refusal of license applications and the revocation of licenses, but the judgment, which has not yet been handed down, is likely to be of broader application, which is why I wanted to mention it, not yet having judgment. It's the second time Hussein has reached the Court of Appeal. Those of you who remember it will be aware that the first time round related to the Rehabilitation of Offenders Act. On this occasion, there were two issues which were somewhat different. I'm going to focus on the first of them, which was about Schedule 5, paragraph 34 of the Housing Act 2004, which is what I've put on the slide here. And in particular, 2B, an appeal may be determined having regard to matters of which the authority were unaware. The first question that the FTT, which rejected this argument, and then the upper tribunal, which rejected this argument, and the Court of Appeal that's been asked to consider it for a third time. The first question it's asked to consider is whether the FTT, was entitled to consider matters only as they existed at the date of the council's decision, or whether later matters can also be taken into consideration, and therefore whether the FTT considers an appeal from the authority's decision, or whether it effectively conducts a de novo rehearing, becoming the primary decision maker for itself. And there are, of course, as with everything, arguments telling in both directions. The council's primary argument is that it is the primary decision maker, so that its decision must be treated with deference, which just can't be achieved if the FTT is entitled to come to a different decision because of matters that didn't exist at the time of the council's decision. The respondent, Ms. Hussein, says that that's absurd because it would mean that if an appellant in the first tier tribunal was subsequently convicted of a serious housing related offence, the FTT wouldn't be able to consider it. And the shortest thing I can say about this case, which is all I can say, both given time and other perhaps obvious reasons, is watch this space. And that leads me finally to the houses noting in particular the time, leads me finally to the Houses in Multiple Occupation Asylum-Seeker Accommodation England Regulations 2023, which have been laid before both houses, which were approved by the Lords on the 25th of May and which await approval by the Commons. What do? On an overview level, they insert new subsections 5A and 5B into section 254 of the Housing Act 2004, with effect from the day after they're made, that is the day after they're approved by the Commons, until the 1st of July 2026. What does that mean? It means that they amend primary statute and they do not have retrospective effect. On a more detailed level, they provide that a building or part of a building which otherwise meets the HMO tests is not an HMO broadly for 2 years if it's occupied by asylum seekers and it's managed or controlled by a relevant landlord. What does relevant landlord mean? It means, someone who's entered into an AASC, an Asylum-Seeker Accommodation contract, with an AASC provider, which is someone we'll look at in a moment, 5BA, or managed or controlled by an AASC provider, which means a person who's entered into a contract directly with the Secretary of State to procure accommodation for asylum seekers. And in either case, the occupation commenced after the coming into force of the regulations and before the 30th of June 2024, which is roughly 2 years before these regulations will lapse. What does that mean in English? It means that a person who has entered into a contract with the Home Secretary directly does not need an HMO license, to manage property that would otherwise prima facie be an HMO, and that a person who entered into a contract with a person who entered into a contract with the Home Secretary also does not need an HMO license. The explanatory note says this proviso, explanatory notes are not law, that accommodation provided on behalf of the Home Office for asylum seekers does not require an HMO license from a local authority during the specified period. That rather lends tacit support to the proposition that local authorities that I've been talking to are suggesting, which is that accommodation currently occupied by asylum seekers can at least be an HMO. How it all works, of course, remains to be seen. And the important point to add is it's not just licensing per se that the properties will be exempt from. It's also management regulations only applying in respect of HMOs arising under Part 2, which has led commentators that I've seen to speculate this will result in vulnerable people being put into unsafe accommodation, and seemingly gives rise to the risk that there'll be a reduction in the availability of private rented sector accommodation as landlords attempt to move to this model, which I understand is not restricted to the local housing allowance and is therefore capable of being more profitable than the PRS. And that, no doubt running over, leads me to the final slide, which is any questions. I think Tara was going to marshal.
I think Ricardo stuck to his time slot much better than I did, so don't worry. There's one question from Ted Murphy, which actually is just relevant to what you've been talking about, Ricardo. Inviting everyone else to leap in with their questions now, but while you type them up, Ted is wondering if the asylum seeker HMO is in a selective licensing area, will it be required to be licensed under Part 3?
Well, the answer to that, I need to go back in my slides. If that's something I can do, is this 5A. It's not a Part 2 HMO. The regulations say nothing at all about Part 3. So I think the answer to that question is it doesn't affect whether a property is required to be selectively licensed.
So I think watch that space is probably the answer.
Well, the difficulty really, as you know, on these regulations is that they haven't been passed the Commons. The Commons have entitlements and not passed them at all. And they've been subject to no scrutiny at all because they're just drafts. So how they'll apply in action, I'm afraid, remains to be seen.
I think that probably applies to a question from Grace House at Camden, which is to do with asylum seeker hotels, or perhaps best described as hotels which are currently being used to house asylum seekers. If they're not HMOs, does it mean the management regulations don't apply, or they're just not licensable HMOs? I mean, Ricardo, will I defer to you to answer that, or? Well,
I'm happy for you to answer.
No, I mean, it's your topic, but
the answer is that they're not HMOs for the purposes of Part 2. That's what 5A, I think it's 5A1 says. That doesn't mean they're not HMOs. So I'll ask this question very broadly in this sense, any provision providing to HMOs per se, rather than licensable HMOs, will continue to apply irrespective of the amendment, the temporary amendment to the underlying section.
I think a final question on asylum seekers, because we've had quite a few. If a provider cannily ceases providing asylum accommodation now and then picks up again after the date the regs come in, if the regs come in, will they then be exempt? What will the effect be once these are enacted? Will they apply to all existing accommodation, or only to new accommodation, new contracts after that date?
Well, that's a question of construction. If during the relevant period, Well, I think the difficulty with the question is that if it ceases to be occupied as asylum seeker accommodation and is then reoccupied as asylum seeker accommodation, I don't see why that doesn't wipe the slate clean. But
I'd agree with that. Yeah, I think what I what I don't know the answer to, I suppose, is what the effect of the regulations as currently drafted would be on accommodation that's already occupied if that continued in place.
Well, as I understand it, because of the time period, the first occupation has to be this. I don't know if you can see my mouse, but 5BE, they have to have it beginning with, it has to begin with the period of 2 years within, I'm thinking on my feet, which is why I'm speaking so incoherently. But the way I understand these regulations and the amendment they make to the primary statute, the occupation has to have commenced after the relevant provisions came into force. So if someone holds over, that doesn't get them through.
Okay. You heard it here first. You can advise your clients accordingly as to what they should do if these regulations are coming into force. We've had a question from Susan about the slides, and whether these slides will be emailed or will be available on the website. I actually don't know the answer to that. I don't think the slides are emailed sort of to all registered participants, but the video will be available, and I think if you'd like a copy of the slides, just drop us a line. Our email addresses and our clerk's email address are on the final slide, and certainly available through our web pages on Chambers website as well, and we'd be happy to share them. I think just we have about 5 minutes left if there's any questions on other topics. Maybe in case some of you missed it, Simon Chambers asked a question which Ricardo very helpfully answered in writing, to the effect that if a CPN is issued against a number of different parties, are they jointly and severally liable, or might the fine be divided between each? And Ricardo answered this in a way that I would certainly warmly agree with, which is this was considered by the upper tribunal in a case called Sutton and Norwich, where it was sort of being suggested that what you should do is come up with a global penalty and then divide it amongst recipients, and that suggestion was rejected effectively. I would certainly advise that if you want to take action against a number of individuals, that you issue each of them with their own CPN. The person named on each CPN is then solely liable for paying their own fine, and if they're different people, I would probably suggest the totality principle does not necessarily apply, but you should have regard to the guidance in Sutton. I think that actually is also discussed in the Court of Appeal decision in Sutton, and you'd have to approach sort of each individual person's fine on its own merits, is how I see it. Ricardo, was there anything you wanted to add on that?
But the interesting point that arises out of Sutton is where the people are the same, whether real people are the same legal person, it's complicated. So in that case, it was a director, a sole director and sole shareholder of a company, both being fined at the same time. Sorry, in that, what I mean by in that case is the underlying case was called Roll Co, which was about the totality point that Tara's just mentioned. And in Roll Co, the shareholder and director were the same person, and the Court of Appeal in that case was pretty stark in its suggestion that you have to consider who the final person having to pay the penalties is.
I think if there's no further questions coming, this is probably an opportunity for us to wrap up, to thank everyone so much for attending this morning. We hope that more of you might be able to watch this later at home. If there are any further queries or thoughts that you'd like to share, just drop us an email and we'd be happy to try and follow up as best we can. And we hope we'll see you all again soon.
Thank you.